My Lady, my Lords, immediately before the short adjournment, I had concluded the citation from Fairchild on whether or not it was founded on impossibility. In our case, we give references to paragraphs in Barker, which we say are to the same effect, and may I take you to those references now? Barker is in tab 2 of the authorities bundle, and the first paragraph that I would wish to take you to is a paragraph which we've looked at already, paragraph 17 from Lord Hoffman's speech. Which I read this morning, yes, and has just before the bottom of the page the reference to the claimant, to the cannot be proved to have done so because it is impossible to show on a balance of probability that some other exposure to the same risk may not have caused it instead. Then paragraph 24. This was where Lord Hoffman was recanting on his view in Fairchild that the causative agent didn't need to be the same. And in paragraph 24, line 4, he says, "In my opinion, it is an essential condition for the operation of the exception that the impossibility of proving that the defendant caused the damage arises out of the existence of another potential causative agent which operated in the same way." Lord Scott...
Why, as a matter of interest, is that an essential condition? I mean, is there any logic?
It's to draw a distinction between this sort of case and the sort of case as in Wiltshire, where there were 5 potential causes for the child's blindness, but they were different. And it was to... logic... possibly, principle, it was to draw a distinction between the Fairchild.
Yes, I mean, obviously, and it seems to me that this citation of the idea that impossibility lies at the root of Fairchild and Barker is almost odious, because it's what else can lie at the root of it? Otherwise, yes, we wouldn't have any general rule of causation at all.
Yes.
But I just wonder what the logic of stopping where people stopped in Barker was. Why is there a distinction between this case and Wiltshire?
Because I think it was felt that there was, and I use the word, yes, advisedly, it was felt that there was a distinction. It was a distinction between making an exception for people whose illness was caused by one particular strand or method of being affected, and I know that doesn't really answer your question.
I mean, it all ends up on the insurers of risks in respect of asbestos, no doubt, but if you had a choice between passive smoking and asbestos, why wouldn't you think that it was fairer to spread the risk between the insurers in respect to the risk of passive smoking and asbestos? I don't know.
Well, the answer to that question is I don't know. In Barker, lung cancer, which can be a product of both smoking and asbestos, was expressly accepted or said to be an exception by Lord Hoffman. Apart from the difficulty of proving liability against people who expose you to passive smoking, there is no inherent bar against suing either someone who's exposed to asbestos or someone who's exposed you to smoking in relation to lung cancer. And certainly in lung cancer cases, smoking has been taken as contributory negligence, but those cases have been dealt with on a conventional basis. And I'm very conscious that I still haven't answered your first question.
I mean, I can see where you've got more than one cause, it's usually a problem which doesn't arise, because in most circumstances you can point to one cause or the other, but there are cases, obviously, where you can't, where science precludes that, and one wonders, yes, if two people are in the arena as possibly contributing to the injury,
Yes.
why it wouldn't be just as fair to spread the risk between both of them if they're both at fault?
Well, isn't the assumption that it's only in mesothelioma cases that science hasn't yet developed to a point where there can be proof on the balance of probabilities, whereas in other classes of case that's not so.
No, because there are examples of other cases where the divide is between Fairchild and Wiltshire. Wiltshire was a case where there were 5 possible causes of the child's blindness, of which one was the negligent feeding of oxygen by the doctors, and the 4 were to do with other things. In fact, the child was very premature. And in Wiltshire, the claimant lost because, and there's a very nice phrase from Lord Justice Brown Wilkinson, as he then was, which one sees, in fact, on the page before the one we're looking at.
I mean, isn't the answer to my Lord John Dyson in the last 4 lines of that paragraph 24? I mean, there it is, lung cancer, asbestos and smoking. You can't prove which is the more likely cause of agent you lose.
Yes, but what my Lord Mance was asking me is why the line has been drawn between things which operate in the same way, and I'm not able to give. Well, I can show you where it comes from. It comes from, I think, the judgment, the dissenting judgment of Sir Nicholas Brown Wilkinson in Wiltshire, which is set out on the previous 2 pages of Barker, the relevant passage. And one can follow it through Fairchild on these 2 pages. At letter F on page 585 of the judgment, to apply the principle in McGee to the present case, that's Wiltshire, would constitute an extension of principle. In McGee, there was no doubt that the pursuer's dermatitis was physically caused by brick dust. The only question was whether the continued presence of such brick dust in the pursuer's skin after the time when he should have been provided with a shower caused or materially contributed to the dermatitis which he contracted. There was only one possible agent which could have caused the dermatitis, viz. Brick dust, and there was no doubt that the dermatitis which he suffered was caused by that brick dust. In the present case, that's Wiltshire, the question is different. There are a number of different agents which could have caused the RLF. Excess oxygen was one of them. The defendants failed to take reasonable precautions to prevent one of the possible causative agents from causing RLF, but no one can tell in this case whether excess oxygen did or did not cause or contribute to the RLF suffered by the plaintiff. The plaintiff's RLF may have been caused by some completely different agent or agents, e.g. hypercarbia, intraventricular hemorrhage, apnea, or patent ductus arteriosus. In addition to oxygen, each of those conditions has been implicated as a possible cause of RLF. This baby suffered from each of those conditions at various times in the first 2 months of his life. There's no satisfactory evidence that the excess oxygen was more likely than any of those 4 candidates to have caused RLF in this baby. To my mind, the occurrence of RLF following a failure to take a necessary precaution to prevent excess oxygen causing RLF provides no evidence and raises no presumption that it was excess oxygen rather than one of the other four other possible agents which caused or contributed to the RLF. The position, to my mind, is wholly different from that in McGee, where there was only one candidate, brick dust, which could have caused the dermatitis, and the failure to cause a precaution against brick dust causing dermatitis was followed by dermatitis caused by brick dust. In such a case, I can see the common sense, if not the logic, of holding that in the absence of any other evidence, the failure to take precaution caused or contributed to the dermatitis. To the extent that certain members of the House of Lords decided the question on inferences from evidence or presumption, I do not consider the present case falls within their reasoning. And then this, a failure to take preventative measures against 1 out of 5 possible causes is no evidence as to which of those 5 caused the injury. And that is a passage which has been repeatedly affirmed and endorsed by the House of Lords. And I think, had I been more alert, had I been quicker, I would have gone there more quickly in answer to my Lord Mance's question. one sees that Lord Bingham followed that up in Fairchild, where he said it's one thing to treat an increase of risk as equivalent to the making of a material contribution where a single noxious agent is involved, but quite another when any one of a number of noxious agents may equally probably have caused the damage. And so the idea, or the reason, I thought, appears to be that if you've only caused one of a number of disparate causes, there's no sufficient justification for imposing liability and treating you as if you have caused. Whereas if you are at least part of a body of activity which has caused, then the fairness follows.
To my mind, that's a distinction without a difference. It seems to me that in the present type of case, if there are 5 possible manufacturers or employers who may have contributed to mesothelioma, it's still no evidence that any one of them caused it, and that is exactly the same as where there are 5 different causes.
But my lord is absolutely right in one sense, that there isn't, the premise upon which Fairchild was based was that there was no reason to assume that 1 out of the 5 tortfeasors,
Yes.
but the fairness on which Fairchild was based was that between them they did it.
Well, I, that's what I'm trying to wrestle for. What is the fairness in drawing the line? And it may be that the only reason at the end of the day is that courts don't want to undermine the general rule. And that...
The reasoning, as I understood, the reasoning was that the risk which they had created had eventuated. Now, you don't know whether any of them actually had actually caused it, because it might not have been any of the defendants in Fairchild. It might have been somebody who wasn't before the court who caused it, but nonetheless, they had created the risk which eventuated. And that, as I said, the passage quoted paragraph 21 here, that was why it was different from the case of Wiltshire, when you couldn't say that the risk which the hospital had created had actually eventuated.
No, unless you define the risk as the blindness.
Absolutely.
The other distinction, whether it's well-founded in logic, is that there's a single noxious agent that has been put in the cases of mesothelioma, or potentially a single noxious agent, possibly coming from a variety of sources. Whereas in Wiltshire, there are, to use the expression, 5 possible noxious agents, and they're all standalone agents.
Yes, yes.
Well, each of them wholly causative, possibly, of the injury.
Yes. But when one uses, I accept what my Lord Rogers says about paragraph 21 and the risk having eventuated. But of course that depends on what you define as being the risk.
Yes.
And one can characterise Wiltshire. I do remember, and perhaps, since I rather suspect I'm not going to finish today, I will look it out overnight. I think that in Barker, the appellants offered the House a different way of distinguishing between Fairchild and Wiltshire, which didn't find favour then, but I might try it again if I can.
may it not be that in the case of the 5 separate causes, you can't argue very realistically, at least in most cases, that they are cumulative, whereas the whole nature of asbestos exposure and mesothelioma is that one actually doesn't know whether they are each exposure gives rise to an entirely independent possibility of creating the risk, or whether there is an element of accumulation, and so that it may be that because of that scientific uncertainty, where you have a single noxious agent is a different case from one where you have a number of noxious causes.
One does at least know that it is that noxious agent which has caused...
Yes, and it may be that the 5 possible exposures do interlink in some way that science doesn't understand.
Yes.
So that, and you can't say that in the type of situation which was an issue in Wiltshire.
No. And the last, it's almost an epigram or an aphorism, the last sentence of Lord Sir Nicholas Brown Wilkinson's judgment cited on page 586 encapsulates the idea. Well, it may be that this citation is Ocho's. May I, having done as much as I have, may I give references to Lord Scott's speech at paragraph 53 and my Lord Rogers' speech at paragraph 98, both of which in my submission make it quite clear that the Fairchild exception is founded on the impossibility because of the failings of medical science. To attribute the mesothelioma. And before moving on, I have not taken you to McGee, but because since this is known as the Fairchild exception, it seems to me more appropriate to look at Fairchild and Barker. But may I simply give you references in case you wish to follow them through in McGee to Lord Reid at page 4, letters F to G and 5A to B. Lord Wilberforce at page 6F and 7E. Lord Simon on the second paragraph of page 8. And Lord Kilbrandon at 9G, all of which found the McGee exception, as it then was, on impossibility. And one other voice to add to this, you have in your bundles the second volume of authorities at tab 30, an article about McGee written by Lord Hope, who was junior counsel to the soon-to-be Lord Mackay for the defenders in McGee. And at page 882 of the bundle, he just below halfway down, having reviewed McGee, he says, if the orthodox explanation must be rejected, what then is the explanation? What was the ratio for decision? The key to the case, I think, is the fact that it was impossible to know which particles of dust caused Mr. McGee's dermatitis. As Lord Kilbrandon put it, the actual chain of events in his body leading up to the injury was not clearly known. And so on. The only other passage in this article that I would wish to draw to your attention is a passage on page 888 of the bundle, page 603. He is now talking about needing to appreciate the true point of McGee because it underlines the true ratio in Fairchild. Is this paragraph, the first main paragraph. If we can take that proposition as our starting point, I would suggest that the answer to the question how far the approach in McGee may take us must depend in the end on the state of the evidence. If the evidence itself demonstrates that there was a breach of duty, but the law of causation has set itself an impossible task because of the current state of medical or scientific knowledge, cannot meet its demands, something is wrong. If the duty has been, as Lord Hoffman put it, emptied of content so that liability cannot possibly exist, the law of causation must soften its demands if it is to meet the requirements of fairness and justice. But that proposition on its own does tell us where the limits lie. As to that point, it is clear that the law will not soften its demands without a good and compelling reason, so it must be demonstrated by evidence that there was only one possible cause, that in subjecting the claimant to that cause, the defendant was a breach of duty of care, and by doing so, it materially increased the risk of injury. but it must also be demonstrated that it is not possible to go further and establish the causal link which the law normally requires. If that is the case, a material increase in the risk will be sufficient to satisfy the causal requirements for liability. Above all, we must remind ourselves that solutions that are needed to deal with exceptional cases are not there to be used universally. So the points that I draw from that, albeit extrajudicial writing from Lord Hope, is that impossibility provides the compelling reason, that an exception such as Fairchild requires good and compelling reasons, and that it remains an exception and that which requires justification, and any departure from normal principles and any extension requires justification by those who propose it.
Mr. Smith, can I just say I in fact share Lord Mance's trouble with this single causative agent, and I am happy to say that that difficulty is shared also by Professor Burrows, and I don't know if you've seen it, but there's an article of his in it's the Journal of Personal Injury Law / Quantum, headed Uncertainty About Uncertainty, Damages for Loss of a Chance, 2008 JPIL issue 1/08. And I mean, if you haven't seen it, it's probably just worth your glancing at it.
I will.
Overnight.
I will. If I have, I don't have it at my mind's fingertips.
He gave it initially as a personal injury bar association lecture.
It is one of the surprising things that there has been not very much academic writing on this area. There are some case comments and a few things, but not much. But by tomorrow morning, I suspect I will have read that, my lord. Can I go to now to look at the way in which courts have approached the use of epidemiological evidence? And can I straight away say that having looked at Hodson over the short adjournment again, I think my Lord Mance is absolutely right, but may we look at that in a minute. We referred in our case to the Australian case of Amarca and Hannell, or Hannell and Amarca, which appears in bundle 2 of the authorities at tab 23. This is a decision of the Supreme Court of Western Australia, or no, it's on appeal from the Supreme Court of Western Australia. It's a decision of the Court of Appeal of Western Australia in a mesothelioma case where the issue involved proof where against in the context of background exposure. And it's an extremely long judgment in all, and I do not propose to take you to more than a small part of it. But on page 613 of the bundle, in a citation from the court below, halfway down the page is a good explanation of how dose is measured in mesothelioma cases. The paragraph starting, the risk of contracting mesothelioma is related to the dose of the asbestos inhaled. An asbestos fibre must be very small before it can be inhaled. These tiny fibres are called respirable fibres. The dose may be calculated by counting the concentration of respirable fibres in an atmosphere. And I do not propose to read the rest of that paragraph, but that measure of calculation, fibres/mil, is the measure which is adopted almost universally, was used by Dr. Jones and Sienkiewicz. And if you convert the cumulative dose in terms of the numbers of fibres in a milliliter of air over so many years, you can then express it as fibres stroke mil years, which is the measurement that Dr. Jones worked with, or a measurement that Dr. Jones worked with. At paragraphs 14 to 16, on page 616, is a section on background exposure, and Professor Breslin, in that case at paragraph 14, gave evidence about average exposure in an urbanized environment. And at paragraph 15, the expression background risk is used to describe the risk of contracting mesothelioma as a result of background exposure. However, as the trial judge found, and consistent with the expert evidence, the absence of a recalled history of specific exposure to asbestos is not the same as an absence of exposure. And at the end of that paragraph, the evidence of Professor Musk, accepted by the trial judge, was to the effect that repeated studies had shown between 15 and 30% of mesothelioma sufferers were unable to recall any specific exposure to asbestos. 16, the expert evidence was consistent that such a group of patients will be made up of at least two subgroups, a group who had in fact been specifically exposed to respirable asbestos fibre at levels above those found in the general environment, but who were unaware of that exposure at the time it occurred or unable to later recall it, and another group whose exposure to respirable fibre was limited to that present in the general environment. There are differences of opinion and no conclusive evidence as to whether the group contains a third subgroup of mesothelioma sufferers, being those who've had no exposure to respirable asbestos fibres whatsoever. And then dealing with the epidemiological approach, may I go, please, to paragraph 31 at the bottom of 623, which is in a section called Causation Legal Issues. And the court needs to know that Australia has not adopted the Fairchild approach or the McGee approach. And so what is being contemplated here is what I would call normal or proof by normal principles. And at paragraph 31, Chief Justice Martin says, from the analysis of the evidence which follows those passages that he's just cited in the judgment below, it is clear that His Honour approached the question of causation on the basis that Mr. Hannell would discharge his burden of proof if he established on the balance of probabilities that the three incidents of specific exposure already identified had increased the risk of him contracting mesothelioma to any extent above that which would be regarded as falling within the de minimis principle. That may be the law of England, but it is not the law of Australia. This was a case in which both sides called experts who expressed opinions on the extent to which the incidence of specific exposure identified by Mr. Hannell had increased his risk of contracting mesothelioma in addition to the background risk in reliance upon epidemiological studies. Indeed, the expert evidence was uniform that epidemiological studies are currently the only basis upon which an assessment of causative effect can currently be undertaken. This is because the precise etiology of mesothelioma remains unknown, and because science has not evolved to the point where it's possible to say, for example, by lung biopsy, which fibre or fibres from which source or sources caused or materially contributed to the disease. And if one goes on to paragraph 37, which is towards the bottom of 629, by citation from a case called McGuinness, Chief Justice Martin refers to expert evidence being led relating to the increase in risk occasioned by the specific instances identified by Mr. Hannell by reference to an epidemiological measure known as relative risk. That measure, which is a measure in standard use, was described by Chief Justice Spiegelman in these terms. And at paragraph 67, Chief Justice Spiegelman identifies what is meant by relative risk. At paragraph 38, Chief Justice Spiegelman then considered the extent to which epidemiological assessments of relative risk had been used by the American courts. At 121, he cited the following extract from the Federal Judicial Centre's reference manual on scientific evidence. The civil burden of proof is described most often as requiring the fact finder to believe what is sought to be proved is more likely true than not. The relative risk from an epidemiological study can be adapted to this 50% plus standard to yield a probability or likelihood that an agent caused an individual's disease. The threshold for concluding that an agent was more likely the cause of a disease than not is a relative risk greater than 2. Recall that a relative risk of 1 means the agent has no effect on the incident of disease. When a relative risk of 2 reaches 2, the agent is responsible for an equal number of cases of disease. Thus, a relative risk of 2 implies 50% likelihood that an exposed individual's disease was caused by the agent. A relative risk greater than 2 would permit an inference that an individual plaintiff's disease was the more likely than not caused by the implicated agent. A substantial number of courts in a variety of toxic substance cases have accepted this reasoning. And then to the bottom of the page, he outlines the position in Australian law that the predominant position in Australian case law is that the balance of probabilities test requires a court to reach a level of actual persuasion. This process doesn't involve a mechanical application of probabilities. And at 137 on the next page, in Australian law, the test of actual persuasion does not require epidemiological studies to reach the level of a relative risk of 2, even where that is the only evidence available to a court. Nevertheless, the closer the ratio approaches 2, the greater the significance that can be attached to the studies for the purposes of drawing an inference of causation in an individual case. The strands of the cable must be capable of bearing the weight of the ultimate inference. And he then speaks at the bottom of the page of relative risk factors low to moderate at 1.32 to 1.58, and says that they were the highest to be relied upon. And then at 44, line 7, 6, for the reasons enunciated by Chief Justice Spiegelman and McGuinness, in this type of case it is necessary for the tribunal of fact to determine the extent of the increase in risk occasioned by the instance of specific exposure which is said to give rise to liability. Because of the view of the law taken by the trial judge, he did not make any finding on an issue which was critical to the question of causation. Then, in passing, at paragraph 99 and following, set out or records how Professor Berry had approached the calculation of increase in relative risk. And at 215, which is on page 682 of the bundle, he says he's had the advantage of reading the reasons to be published by his brother judges. I think they're both brothers. I think the essential difference between us on the subject of causation is that, unlike their honours, in my opinion, the expert evidence did not establish that asbestos fibres from all sources make a cumulative contribution to the contraction of the disease. In my respectful opinion, the expert evidence went no further than to suggest that increased exposure to respirable asbestos fibre increased the risk that mesothelioma or some other lung disease would be contracted. And as we shall see in a minute, because the other judges took the view that it made a cumulative contribution to the contraction of the disease, they adopted a Bonington approach. And finally, out of the Chief Justice's judgment, he concludes his assessment at 217 and 221, saying the relative risk is only at 1.3 to 1.4, and it falls far short of proof of causation. My lords, the approach of the majority can be seen at paragraphs 397 4 lines from the bottom, summarising the evidence. They find that an exposure, so this is on page 734, or 126 of the judgment, 734 towards the bottom page, 4 lines from the bottom. They take the view that an exposure to asbestos that made a cumulative contribution to the contraction of the disease can be a material contributing factor even if it was not itself a sufficient cause, and they rely upon Bonington for that. And we see that, if one goes to paragraph 413, they say the approach to causation in Bonington, this is on page 739, I do apologise. The approach to causation in Bonington is conventional and has been approved. And they say, last 4 lines, that epidemiological evidence is of no assistance in answering the question whether or not, as a matter of fact, a negligent act or omission contributed to the injury that may have been of assistance in determining whether a contribution was material.
Well, was expert evidence given that cumulative exposure to asbestos was productive of mesothelioma in that case?
Well, it was different interpretations. I'm not in a position immediately to direct you immediately to it.
No, well, I don't need to be directed to it, but does this represent a preference on the part of the majority of one strand of evidence over the other?
It represents a preference to treating the causation of mesothelioma as a cumulative, as a product of the aggregated disease.
Oh, quite, I can see that.
Yeah, I'm sorry.
But was that based on scientific or medical evidence given to the court?
The reason why I hesitate is that when I read it entirely through, I was not sure that it did, but may I be in a position to answer your question tomorrow?
Yes, of course.
I don't think it has citation. My lord, can I clear my error on Hodson?
So what would you like us to take from reading all these hundreds of paragraphs?
From these paragraphs that it is a conventional approach and an acceptable approach in at least one other jurisdiction, obviously, in Australia, to address the causation of mesothelioma by reference to the question of relative risks. And that the exercise of looking at increase in relative risk as a means of proving probability under conventional principles is not I think I've got too many knots in there. But that proving probability by reference to epidemiological evidence of probability is an acceptable approach to evidence and fact-finding in law.
And that would be applicable even in a pure, if I can use that word, pure fair child situation. Even you had a number of tortfeasors who had all of them exposed the claimant to asbestos dust. In Australia, they don't adopt the Fairchild solution, and so this approach, or either the majority or the minority approach, not sure which, would be applied even in that situation.
Yes, where Fairchild does not apply.
Sorry, I thought Fairchild didn't apply.
Fairchild doesn't apply in Australia.
Yes.
And so therefore they are wrestling with proof
Yes.
on conventional principles. And the distinction between the majority and the minority was that the majority appear to have treated the causation of mesothelioma as being like Bonington, where the aggregate dose all cumulatively applies and contributes. The minority, Chief Justice Martin, was saying that you can prove on the balance of probabilities by reference to epidemiological evidence, and that the expert evidence was to the effect that the use of epidemiological evidence to prove probability in an individual case was the only way that it could be dealt with. And it's really for that that I've gone to the case at all.
So there isn't the rock of uncertainty in Australia?
Well, there isn't the rock of uncertainty in a single exposure case, which is what this is, and they have not adopted Fairchild as a solution to the rock of uncertainty in a multi-exposure case.
I'm puzzled by this because if you look at the concluding paragraphs of the majority's judgment, paragraphs 417 to 420, they say in effect that by a different process of reasoning they've reached the same results as McGee and Fairchild. And the different process of reasoning is based on, I think, Mrs. Justice Gordon's dicta at paragraph 392, which are effectively the fiction that where you have an injury occurring within an area of foreseeable risk, then you deem it to have been the breach of the common law duty as duly caused or materially contributed to the injury. That was the fiction which the House of Lords dispelled in McGee, but it's another way to the same result.
It's saying that it is, well, it's another way to the same result, but it's not the Fairchild approach.
Well, it's not the same process of reasoning,
No.
but to say they don't have the same approach when they reach the same result is perhaps oversimplifying, isn't it?
Yeah.
I think it's the same point that Jane Stapleton makes in her article, isn't it? The penultimate one in the bundle. Namely, that Australia doesn't have the Fairchild approach, but they get there by a different process of reasoning.
Yes. Yeah.
But the claimant lost.
The claimant lost because of a failure to prove duty, breach of duty. Would you give me 1 minute? Yes, but you would want on either side. Could we go to Hodson?
Unaccountably, we don't seem to have it at first instance.
No. But my Lord's findings are at page 779 of the report, which is at page 308 of the bundle.
There they are in all beauty. The genuineness. The genuineness.
At letters E, F and G. And on reviewing it over the short adjournment, it did seem to me that my Lord Mance was probably right in saying that the 75% here was an expression of confidence rather than an expression of epidemiological probability. In which case, it doesn't really contribute to the argument that I'm attempting to pursue, which is that it is conventional to use epidemiological evidence to prove causation on a balance of probabilities on conventional principles in a normal case.
My Lord Mance certainly seems to be right if one only reads 1, but then when one gets on to 2, that 75% risk was translated into an inevitability. That really
Yes.
weighs the other way.
Well, the temptation at this point is to invite the court to resolve this difficulty itself. But for the purposes of an argument where I am looking to draw on expressly stated epidemiological evidence, I think that there isn't really material for my argument there.
Well, I mean, I can't remember. I rather thought perhaps I had heard epidemiological evidence, but I don't know. But it's, I mean, if you look at the report of the case, you'll see if I did or didn't.
Well, put that on the list.
This is on the next page.
779, it says on 779.
Statistically,
Well, the use of statistics was discussed extensively in Greif and Scott, which is in tab 9, the previous tab. And the passage that I was going to take you to was the passage from the judgment of Lord Nichols, who dissented in the result, at page 229 of the bundle. Which I pick up halfway through the paragraph, just below B. In cases of medical negligence, assessment of a patient's loss may be hampered to greater or lesser extent by one crucial fact being unknown and unknowable, how the particular patient would have responded to proper treatment at the right time. The patient's previous or subsequent history may assist. No doubt other indications may be available, but at times, perhaps often, statistical evidence will be the main evidential aid. Statistical evidence, however, is not strictly a guide to what would have happened in one particular case. Statistics record retrospectively what happened to other patients in more or less comparable situations. They reveal trends of outcome. They are general in nature. The different way other patients responded in a similar position says nothing about how the claimant would have responded. Statistics do not show whether the claimant patient would have conformed to the trend or been an exception from it. They are an imperfect means of assessing outcomes even of groups of patients undergoing treatment, let alone a means of providing an accurate assessment of the position of one individual patient. And if one goes to 33, paragraph 32 on page 230, at letter C, he's discussing the value of statistics depending on their quality, and says, but to reject all statistical evidence out of hand would not be acceptable. This argument, if accepted, would effectually nullify the use of statistics in all cases of delayed treatment, save perhaps where the figures approach 0 or 100%. Despite its imperfection, in practice, statistical evidence of a diminution in perceived prospects will often be the nearest one can get to evidence of diminution of actual prospects in a particular case. When there's nothing better, courts should be able to use these figures and give them such weight as is appropriate in the circumstances. The Court of Appeal have applied the approach of relative risks in the case of Novartis, which is also in Bundle 1 at tab 16. And may I take you first to paragraph 53 on page 465. This was a case of carcinoma of the bladder where there were two agents at work, smoking and asbestos. Paragraph 53, the two experts heard the evidence in the case before giving their own evidence. And then about 3 lines further on, the question was put to Mr. Barnard in the form of relative risk, and he therefore expressed his view in a different way from that used in 2005, when he'd estimated that occupational exposure had made a contribution of 70 to 75% of the total risk. In oral evidence, he said that occupational exposure had more than doubled the risk due to smoking. These two ways of expressing his opinion were entirely consistent, and no one has suggested otherwise. Mr. Barnard also made it plain that he thought that the main exposure had taken place in the early years and was related to the use of alpha-naphthalamine in flake form with a high level of beta-naphthalamine impurity. A carcinogen in the later exposures was just a smaller addition. I don't think we need that. Paragraph 74. Having held that the recorder's approach was wrong, the Court of Appeal, Lady Justice Smith, with whom Lord Justice Sedley and Sir Mark Potter agreed, said the evidence of Mr. Barnard with the recorder accepted was that occupational exposure accounted for 70 to 75% of the total. Put in terms of risk, the occupational exposure had more than doubled the risk due to smoking. In my view, if Mr. Feeney is right and the correct test for causation in a case such as this is the but-for test and nothing less will do, that test is plainly satisfied on the facts as found. The natural inference from the finding of fact that the occupational exposure was 70% of the total is that if it had not been for the occupational exposure, the respondent would not have developed bladder cancer. In terms of risk, if occupational exposure more than doubles the risk due to smoking, it must, as a matter of logic, be probable that the disease was caused by the former. As mentioned in our case, Mr. Justice Mackay has adopted the same approach. He, I think it could be said he pioneered or was the judge in a case which achieved a degree of notoriety initially, and Shortell is a much later case concerning lung cancer. It's in the second volume of the authorities at bundle 20, at tab 20 rather. The report starts at page 561, and may I take you to paragraph 33. Paragraph 33, Mr. Justice Mackay set out the propositions which were effectively agreed by the experts. 1, both asbestos and tobacco smoke are established as risk factors for the development of lung cancer. 2, in each case the risk increases in approximate proportion to the dose of asbestos received or the amount of tobacco smoked. 3, there's a multiplicative interaction between the two risk factors, with the result that when both are present, the overall risk is much greater. So that the effect was, well, according to a leading North American study, they found a risk factor of smoking of tenfold from asbestos of 5-fold, and where both hazards were present, 50-fold. 4, current mainstream medical opinion does not hold the view that the risk of lung cancer from asbestos is confined to those who've developed established asbestosis. We needn't worry about that. If I go to 6, at a level of 25 fibre per mil years, the risk of lung cancer is approximately doubled. If Mr. Deary's estimate of 99 is right, which the judge held it was, that exposure on its own increased his risk of developing lung cancer by a factor of approximately 5. If we then go to 37 and 38, having referred to a work from Doll and Pito, which refers to the synergistic effect of asbestos and smoking, Mr. Justice Mackay said, it may become relevant to undertake an exercise seeking to identify or partition the contribution of each of these agents. For his part, Dr. Rudd approached the matter in this way. He estimated the deceased's risk factor from asbestos exposure at 5-fold, acting synergistically on a 5% risk of lung cancer from smoking, giving a risk from both hazards of 25%. The synergistic effect of the asbestos has therefore increased his total risk of lung cancer from 5 to 25%, with an increase of 20%. Asbestos has therefore accounted for 20 to 20 over 25, i.e. 80% of his total risk. If the deceased had in fact smoked until a later date, then his smoking would have conferred a risk factor of 8% for the development of lung cancer. This would have increased 5-fold by the effect of asbestos, increasing his overall risk from 8 to 40%. And therefore, says it's Dr. Rudd's view that the deceased's asbestos burden in itself would have satisfied the Busford test, and in combination with smoking did so too. And 47 to 50, he deals with the legal test for causation. He dismisses Fairchild as being inapplicable in 47 and 48. And he says that the causation of lung cancer as opposed to mesothelioma is dependent on an aggregate dose of either asbestos fibre or smoke. Mr. Feeney rightly concedes that if the claimant proves on a balance of probabilities that the risk factor created by his client's breach of duty more than doubled the deceased's relative risk of contracting lung cancer, then the claimant's case is proved. And he goes on to say the only remaining issue is contributory negligence. And he says he's found it. So I refer to this as a case at a lower level where the court has been content to make findings on the conventional principles by reference to what is essentially epidemiological evidence about increasing risks. And what we saw this morning that approach was adopted in Jones and Metalbox, His Honour Judge Higginbotham's case. I don't take it back to that. And the attitude of the Court of Appeal in Sienkiewicz was that, subject to any contrary view from this court, it is now established that on conventional principles of causation, causation can be proved by reference to an increased risk, relative risk of a factor of 2. And we see that in the judgment, the Court of Appeal's judgment in Sienkiewicz. At paragraphs 19 to 23. On page 12 of the bundle, paragraph 19 of the judgment starts, in the light of those authorities. And Lady Justice Smith reviews the English experience in paragraphs 19, 20, 21 and 22. And then at 23 says, in my view, it must now be taken that, saving the expression of a different view by the Supreme Court, in a case of multiple potential causes, a claimant can demonstrate causation in a case by showing that the tortious exposure has at least doubled the risk arising from the normal cautious cautious cause or causes. So,
Just at the end of paragraph 20, penultimate line, shouldn't it be 1.1x? Otherwise you're trebling it.
no, because
You haven't got to treble it, you've only got to...
no, that is, I think that is right.
Yes.
Yes.
Is it right? X is 1, so it's going up to 2.1.
It's got
Yes.
more than double.
The problem is, or the difference is, whether you're looking at cumulative risk
Yes.
or whether you're looking at two alternative possible risks.
If the Lady Justice was saying the risk solely attributable to the potential, or the incremental risk solely attributable to cause B, she should have said 1.1. If she's in fact there referring to the aggregate risk after the addition of the risk from potential cause B, it would be 2.1.
Well, she's told you what X is, it's the risk from potential cause A. And all you've got to show is that the risk from potential cause B is higher.
Yes. Yes. And perhaps at too great a length, I have been seeking to satisfy the court over the last half hour or so that it is now conventional to do that by reference to epidemiological probabilities, and that they are acceptable. That is an acceptable way of approaching conventional proof.
But I mean, if that is so, I don't see why it couldn't apply equally to the Fairchild situation.
Nor do I. I cannot give a proper statistical explanation. I know because every time it's explained to me, it is because of the function of randomness within the operation of the asbestos fibres. And I am, whenever I raise it, because needless to say, it would be an interesting issue to bring before the courts for future determination. Whenever the issue is raised, the answer comes back the same.
Well, there's just a breakdown in logic somewhere in paying attention to the extent of exposure on the one hand, and saying, but the extent of exposure tells you absolutely nothing about the cause because it's so random.
In a multiple
Yes.
Fairchild case. But that is the rock of uncertainty upon which Fairchild is premised. I do not accept that it is a rock of uncertainty which affects a single exposure case.
I don't follow that. You keep saying it's a single exposure case, but in fact, one is weighing, is one not, two possible causes. One, the ambient exposure, and the other, an additional occupational exposure.
One is, and I cannot identify for you satisfactorily the logical distinction that applies. What I do know is that claimants on both sides of the divide, there has been a conventional historical assertion, which was made in the case of Sienkiewicz, that you could infer from the fact of exposure that it was occupational exposure, that it was the occupational exposure which was causative.
Just by applying a simple epidemiological approach.
Well, didn't resort to that. Just said the tendency tends to be just to say it's obvious, and it is frequently not challenged where the dose of the occupational exposure is sufficient.
But it's premised on the fact that what really matters is the dose or the amount of exposure.
Correct.
In that case,
Correct.
albeit that doesn't seem to be a permissible approach in any other case.
Correct. Correct. What I would say about that in what I'm going to go on, with your Lordship's leave, calling a single exposure case, is that the evidence of predicted risk may not be, well, certainly isn't perfect for the reasons which have already been covered in the course of today. which is one of the reasons why I accepted this morning that you don't do a pure and precise mathematical formula and cut off at 2, but that it is evidence which is relevant and admissible, and where the product of that exercise leads to the conclusion that the increase in relative risk is far short of 2, then that is matter which the court can and should take into account in deciding that the mesothelioma was not, in legal terms, caused by the occupational exposure.
Paragraph 23 in Lady Justice Smith's judgment, is that a statement, is that a legal proposition?
Paragraph 23.
23 in Lady Justice Smith's judgment.
Yes.
That is a proposition of law.
But it is a legal statement. It is saying that the court will accept that as a means of proof of causation. Or have I misunderstood?
No, it's just, that is that's now...
That's established, subject to any contrary view.
That's a proposition of law, is it?
Yes.
And you've shown us the authorities for that. I haven't understood any of them so far, but those ones you've shown us it's based on statistics, is it? They've given rise to this proposition.
I haven't shown you authority before Lady Justice Smith saying this can be done. What I have shown you, I've shown you the passage from Lord Nichols in Gregg and Scott, where he says it may be the best aid. I could show you
No,
I didn't think you were encouraging me. But there are citations in America where the same approach is adopted, and where the courts recognise that this is not, it's not perfect because it's not specific.
Yeah.
But it may be best evidence or acceptable evidence for the purposes of proof.
So in a Wiltshire case in future of 5 possible causes, if you could, on the epidemiological evidence, show that actually it is, whatever it is, the percentage is, it is over 50% more likely to have been cause A than B, C, D, E together, you're home.
I suspect that on the facts of Wiltshire, all you would ever be able to show were that the factors the other 4 factors were effective on such a vanishingly small number of cases, because I suspect you would never be able to demonstrate, I strongly suspect that you would not be able to demonstrate by reference to epidemiological evidence that the balance between the negligent use of oxygen and the other 4 factors could be shown by epidemiological route to be that the oxygen was more probable. But if you could, the evidence would be admissible. That, I think, would be my answer.
Without taking us to it, before Lady Justice Smith uttered this principle, is there any statement of law that where tortious exposure has at least doubled the risk, that establishes that from the epidemiological evidence that establishes liability? I'm sorry to interrupt, but because my perception so far has been that what the various judges have been saying is, where you don't have any other evidence, then epidemiological evidence is admissible. The weight to be attributed to it will depend on the particular circumstances of the case.
My Lord, I would accept that as being an accurate representation of the position as it is at the moment. I do not have for your Lordship a case where the issue was whether or not epidemiological evidence could and should be admitted, and whether, if so, relative risk of 2 was the touchstone.
But its weight was to be determined on a case-by-case basis. Here we seem to have evolved to a statement that where it reaches a certain level, that will establish liability. Now, what happened to produce that statement?
I think the only answer I can give, my lord, is the review of the cases that preceded it in the previous four paragraphs. And the fact that it is undoubtedly the practice of the lower courts to accept. And where, for example, Mr. Justice Mackay did it on a concession, as we saw in Shortell, he at least expressed the view that the concession was rightly made. And where this started was in the case to which Lady Justice Janet Smith refers at the outset, XYZ, which was large-scale contraceptive litigation. And it was agreed as a preliminary issue that the epidemiological evidence should be addressed. And in the event, Mr. Justice Mackay held that there was no increase, and the claims to a level of 2, and the claims failed. And that was, although it was not a decision of the higher courts, and I don't immediately remember whether or not it was a reasoned decision or reasons for adopting that approach in that judgment. But that has set the path or set the course ever since. I think that is the best answer I can give you.
Yes, thank you.
Sorry, I really don't understand. But supposing that the risk originally from the non-tortious, as described cause, was 5%, and the new one brings it up, bring in this tortious cause, it takes it up to 13%. Is that enough?
Terribly sorry, my lord, I couldn't hear.
Sorry, start the non-tortious cause. There's a 5% chance of you developing it.
Yes.
You bring in the tortious cause, and now it is, say, 13% chance. That's enough, is it?
Yes.
But once looking with hindsight,
If the relative risk has increased from 5 to 13, that would be enough.
And the risk is eventuated.
Yes.
That's the point.
And the risk of
when you stand back and you say the risk of it happening has been increased by 5 to 13, and then you ask, now I've got to ask myself, we know it did happen.
Is it more probable?
Is it more probable? So it's a quite different question. How likely is it that A or B did cause the disease, and how likely was it that it would? And you get a completely different answer.
They're different questions.
Yes.
They're different questions. But once you know, on my Lord Rogers example, that the predictive risk has gone from 5 to 13, however you care to express it, it is more probable, or it is evidence that it is more probable that the outcome is attributable to that which took it from 5 to 13 than that which took it from 0 to 5.
It takes up to 9.5. No.
But if it were to be suggested that it was absolutely precise as a science,
9 then, let's say, or 8, or whatever.
well, as you get further away, so it becomes less valuable to the person who's trying to prove the balance of probabilities in their favour. If, as you've got here, what you have in Sienkiewicz is, depending on which, if you take the case even at the best for Mr. Melson, where it's an increase of, say, 4 out of over 10, so it goes from 10 to 14, that sort of order, you still are, in common parlance, miles off. And for all the difficulties that are inherent in carrying out the exercise many years after the event and the imprecisions of it, it is evidence which supports a judge's finding that the mesothelioma was not caused by the occupational exposure. I do not propose it as a pure mathematical formula where a bell rings at 2 and you either win or lose.
Why not, if there's nothing else?
The reason why, even if there's nothing else that I would wish to qualify it, is that the trial judge should take account of difficulties and imprecisions in the process of the calculation, if there are some, which there normally will be.
So
So
it makes it more difficult for the claimant.
Yeah.
not necessarily. Not necessarily, because if you, the trial judge may, once it gets up to a certain level, take the view that either in conjunction with the other evidence or on its own, there is a margin for error which suggests that the benefit should be given to the claimant. So if
But
for
you've almost succeeded, and therefore you should win.
No.
I mean, that's
No, no,
I
no, no,
find
no.
that
No, no,
I
no.
can see if there's other evidence, of course, that changes the ball game. But I don't understand it if there isn't other evidence.
But if there's no other evidence, you may have a case where the indications from the epidemiological evidence are that it's there or thereabouts. It would a trial judge would be perfectly entitled to say, given the difficulties of this evidence and that it could go either way, in a case of mesothelioma, the evidence in fact indicates that we are at or about the level where it is material. I'm dealing with mesothelioma. I have established breach of duty. I am satisfied on this evidence that the mesothelioma was caused by the occupational exposure. But it is unlikely that it will ever be the only evidence. And for example, trial judges will typically be in a position to, as well, supplement the exercise if they know that there are gaps in the evidence of the exposure. Or they can say that they think that there may be an underestimate, that the expert has undercooked the calculation.
Well, it becomes much more complicated in practice because normally you expect a 10-year gestation period before the disease is apparent, let's say. And so looking to exposure up to 10 years ago, that weighs fully. But the exposure 9 years ago, the expert wouldn't necessarily discount that altogether as
Yes, he
being...
would. 9 years ago he would, because the received wisdom at the moment is that...
If 10 years is a minimum,
No, 10 years is a working minimum.
well, if it's a working minimum, I can see that, but there must be a grey area. You can't say that in every single case, or I suspect no expert would say in every single case, any exposure more recently than 10 years can simply be discounted.
The position is very, very close to that.
Is it?
Very close to that. You would almost need proof positive that someone had never been exposed to asbestos until a period less than 10 years before. I'm trying to remember, I'm sure that there was evidence about this in Trigger.
Yeah.
And there may be one or two cases where the puzzle has arisen, but there's no apparent. Just as there were in the Trigger litigation, we found 2 cases of mesothelioma which spontaneously regressed and went away. But for all working purposes, that is not the assumption on which people work.
Presumably that may be based on statistical evidence, epidemiological evidence. Their conclusion that 10 years is the minimum.
Yes.
I don't know. I'm just wondering.
Whether it's epidemiological or whether it's simply observational, I'm not sure. But it is certainly deeply entrenched that if you die from a mesothelioma, 10 years before is about the time of it. There is some give and take. And
Is the epidemiological evidence related to the circumstances of the person's life? In other words, let us suppose you're a draftsman in Holland and Wolf. You're exposed to asbestos over an 18-month period. You then become a missionary in Brazil and 40 years later you develop mesothelioma, where does the epidemiological evidence rest in those circumstances?
Well, I would give two answers to that. One is the matter would not trouble the courts, because if you worked in the ships in Holland and Wolf for 18 months, and that is your only known exposure, and you develop a mesothelioma, no defendant is going to contest the issue.
Nor did it. Nor did it in that particular case.
Exactly.
But quite so. But let's suppose a defendant is misguided enough to undertake a defence of the case. What evidence of an epidemiological nature would he marshal?
Well, the defendant, I think, well, I almost would wish to defer to Mr. Feeney on this, since it is, but my response would be that the defendant would be extremely hard pushed, because the epidemiological evidence would be that the background risk, if you ignore the period at Harland and Wolff, was particularly, would, if anything, have to be downgraded, because he'd been in the jungles of Brazil for 40 years, which may be about the only place where you won't find any asbestos. And he had been exposed to what would inevitably be found to be heavy doses over
No, not at all. On the contrary, he worked in the draftsman's office, and his exposure was relatively light.
Well, even so, when one looks at the facts of Sienkiewicz and looks at the lightness of the exposure there, where detailed findings were made by the trial judge, it takes very light exposure, intermittent light exposure, for a judge to be able to make the findings that he made in the case of Sienkiewicz.
I think the answer to the question is that one's life circumstances do play a part.
They would. They would. My Lord, I was going to leave the question of proof by reference to epidemiological evidence, and I was going to pick up what is in our case at pages 12. So finishing off my submissions on single exposure cases. And I need to deal with the submission made by my learned friend Mr. Allen at paragraph 3.4 of his case, which is on page 9 of his case. At 3.4, he says that the single exposure argument is contrary to authority in that McGee involved a single exposure. Mr. McGee was not exposed to dust from two sources. He had an exposure to brisk dust, which initially was not tortious but became a breach of duty because it remained on his skin longer than it should. I don't accept that that is a correct analysis. What would be a correct analysis would be that there were two untoward exposures which compounded the possibility of proof on normal principles. and that is why it's not to be treated as a single exposure case. There was no question of ambient exposure. There were two separate exposures to the same pathological source of risk. It would have been, or could have been treated as a single exposure case if both exposures could be treated as one. So, for example, if both had been tortious, then the question would be straightforward. Whereas in the cases with which you are concerned, Sienkiewicz and Willmore, the exposure for which the defendant, it doesn't count in Willmore because we're treating Willmore as a Fairchild case, but in Sienkiewicz, the exposure for which the defendant was responsible can be treated as one with no confounding features.
I mean, you're being driven to try to distinguish between single exposure cases and others because you want to chisel out a little exception to Fairchild for single exposure. But if in McGee there had been firm evidence that brick dust is much more damaging when it first goes on the skin than after it's been there for an hour, and the vital thing is to remove it straight away. But if you leave it there, there is an incremental effect, but not nearly so significant, that could have determined the result.
That could have determined the result, depending on the facts, yes.
But I mean, McGee, nobody could say which was more likely. That was the problem, wasn't it?
Precisely,
yes.
Precisely. And that's why I draw, that's the distinction that I was trying to draw between where you had what were effectively two exposures which confounded each other. And it's that they confounded each other, which is the other side of the coin of what my Lord has just said. Because if they hadn't confounded each other, if you had been able to determine what their respective contributions were, then the case would have become simple and straightforward. Yes, I say I'm driven to chisel out the exception, or to take out of the exception single exposure cases by the reasons that I put forward in the case, namely that it shouldn't apply to ambient and so on. But it is inherent in that argument that you can determine them on conventional principles. So, my Lord, with that, can I turn away from the section of my case which dealt with single exposure cases, and indeed the section of my case which dealt with proof of causation by reference to relative risks? One then comes in our case on page 14 to a topic which, upon review, again, before coming before the court, I'm not sure advances the argument before this court on these appeals to any great extent. It is a debate which has raised a lot of interest, and it arises from Lady Justice Janet Smith saying at paragraph 27, as we set out at 317 of our case, in Barker, as I have said, the House explained the juridical basis of the Fairchild exception not in terms of a pragmatic solution to difficult cases, but in terms of the recognition of a hitherto unrecognised tort, that of negligently increasing the risk of injury. Now, my Lord, in our case, at pages 14 and 15, we have set out in some detail and with all necessary citations why we dispute or question whether or not Barker did in fact create a new tort. We come to the position at 326 that if it is a new tort, it is unique in a number of respects because it is a tort in respect of which a claimant cannot sue. And therefore, we submit here that the better view is that the gist of the tort is and remains the damage of the disease. This, I suspect, may become a much more necessary battleground next year or whenever it may be, because there will be those who assert that because the injury was not suffered and the cause of action was not complete until the onset of the mesothelioma, an insurance policy which covers injuries sustained should not be interpreted to cover that event. And
Should cover,
and
not
unless-
interpreted to cover what event?
to cover the liability arising out of the employer's liability for the ultimate mesothelioma. In employers, can I go back, can I wheel back one sec? In employer's liability, there are a number of policies which have been in existence for very many years, which provide an indemnity in respect of injury sustained or disease contracted during the policy year. And the issue in the trigger litigation, which is on its way here, is whether you can say of a mesothelioma where you inhale the asbestos 40 years ago, but you only realize that you're in trouble or are in trouble in the 10 years and then as you die, whether the policy that responds is the one in existence when the mesothelioma starts, or 5 years into the mesothelioma, or at the time that you inhale the asbestos. I ask you not to express a view at the moment. And anything I say comes with a health warning and will definitely be tendentious.
How is that said to depend, as a matter of interest, on whether the liability is for creating the risk or is for causing the injury?
If Barker creates a new tort of creating a risk, it could, by some, be argued that the tort is complete and the damage is at the time.
But presumably the contrary argument is it's creating the risk and the risk having eventuated.
Yes.
And that, therefore, on that basis, it wouldn't make any difference.
Well, my Lord, what the position that I'm taking this year, and I suspect and hope, if I'm still instructed, the position I shall be taking next year, is that Barker does not, in fact, create a new tort. But I do not, at the moment, think that it advances the appeals today. And therefore, what I was proposing to do was to leave that section of my case unless you wanted me to develop it.
We can deal with this case without deciding that one, is that right?
Yes, I believe so. Can I return to the battleground of what is a material increase in risk in the context of the Fairchild exception, which I called this morning my issue 2. And we have covered quite a lot of the ground already this morning. We deal with this in our case at pages 16 through to 21. And I outlined this morning the threshold test for which we contend. And the submission is based upon the following propositions. First, material increase in risk should have some meaning. Secondly, it has never been defined. Thirdly, if it is assumed that any exposure gives rise to a material increase in risk, that really deprives the word material of any meaning at all. In paragraph 3.28 of our case, on page 16, we acknowledge the fact that a person who has been held in breach of a common law duty of care has, by definition, acted in such a way as to give rise to a foreseeable risk of injury. But we do not accept that the mere fact that you give rise to a foreseeable risk of injury means that the contribution to risk is material so as to attribute the success, the mesothelioma to that breach. There is very little academic writing on the point, and as we've indicated in our case, the one article which addresses this most fully is an article by someone who has a clear connection, which we set out in footnote 16 of our case, with our legal representation. But it is an article by Per Laleng, which is at tab 31, page 890 of the bundle. And the passage in this to which I would wish to refer you is at page 893. Where, having referred to passages from Fairchild and Barker, and picking up at the bottom of 892, he says, Lord Hoffman has come closest to identifying the factual question which the law requires an answer. For him in Fairchild, at paragraph 52, the factual question is simply, has the law's causal requirements been met? Continuing at 54, he suggests that those requirements are not expressions of some form of logic, but creatures of the law. And Lord Bingham agreed at paragraph 20, when approving the aphorism that the legal concept of causation is not based on logic or philosophy. Reducing the factual question in this way not only means that all causal questions would be questions of fact, but also becomes confusing when the real question being asked seems to relate to the proximate cause, which in orthodox thinking is a question within the realms of legal causation. So he is complaining, as I understand it, that factual and legal causation and breach of duty are being run into one. And in the next paragraph, he says, the lack of clarity becomes starker after a moment's thought about the possible meaning of the material increase in risk test for causation. Its jurisprudential sources can be traced to Bonington via the two other Scottish cases of Nicholson and McGee. Although McGee is usually credited with being the progenitor of Fairchild, the role of Nicholson within the jurisprudential development should not be underestimated. Although Nicholson is more akin to Bonington than McGee, both Lords Bingham and Roger in Fairchild highlighted the relevance of risk creation to the causal analysis provided in Nicholson. Lord Hoffman also emphasised at 56 the doctrinal connection between rules relating to breach and causation. This doctrinal connection between breach and causation is significant for the argument presented here, because a defendant in breach of a common law duty of care has by definition increased the risk of damage by such conduct. Risk can be defined as the product of the probability of an event and the happening of severity of harm. My Lord, what is being said is, on behalf of the respondents, effectively, is that once you prove a breach and any exposure, that is sufficient with no further control to satisfy a test of material increase in risk in Fairchild. And we, even though it is not possible to attribute, to decide causation on conventional principles, in a pure Fairchild case, we would not accept that every increment in risk, even though it be sufficient to give rise to a finding of breach of duty, necessarily increases the risk by enough to justify the court in holding the defendant liable for the mesothelioma, even under the Fairchild doctrine. And so what we are suggesting, as my Lord Phillips rather unkindly suggested was off the top of my head this morning, is some form of restraint so that people who are at risk of being fixed with liability by the Fairchild exception may have the potential unfairness softened to some extent simply by giving the word material some meaning. I don't...
Some defined meaning.
Yes, well, we offer a defined meaning.
Reasonable likelihood.
Yes,
Would you care to define that?
yes. Increasing the background risk by a factor of more than 2.
Yes. That's what I thought you meant.
Yes.
But what's the rational basis for choosing that, apart from what Lady Justice Janet Smith has said?
Well, the rational basis for choosing it, my lord, is that if you have an exposure which, viewed on its own, would not lead you to conclude that it was probably the cause of the mesothelioma, there is no justification for putting it into the Fairchild pot simply because there are other Fairchild qualifying causes as well.
Yes, but why choose 2? Why not 1.5?
Particularly when I have said it's not a precise mathematical formula. The answer is that we have expressed it as an increase of 2 as being a way of, well, one could express it in a different way, as being that the risk from the exposure would be sufficient to justify a finding of causation as against background risk. And we have offered the touchstone of an increase of relative risk of 2. So if the position is that if you only had this one exposure and any background risk, you would not say of that exposure, yes, that is the cause of the mesothelioma. It should be left out of account. So it is, the idea is as simple as that and it does not admit of very much elaboration.
But the choice of 2 sounds as if it is derived very much from the balance of probabilities. I mean, aren't you really introducing the balance of probabilities test under the guise of material increase of risk?
No, they're 2 different questions. The first question is whether, if viewed alone, you could or would conclude that it was a cause of the mesothelioma. If it passes that threshold test, you then have still have the Fairchild problem that you've got a number of other exposures which also pass that test, as between which you cannot choose. And to all of those, the Fairchild exception applies. So this is a prior stage, if you like. It's a qualifying stage for getting into the Fairchild enclave.
Just define the qualifying stage. What is it you prove to get into the Fairchild?
You prove that if viewed alone, this exposure would lead, if you viewed this exposure alone, you would conclude that this exposure was the cause of the mesothelioma. And that takes into account the fact that mesothelioma is a signature disease. It takes into account all the uncertainties that I was making submissions to my Lord about earlier.
But this might be an acceptable proposition, having regard to the statistical fact that ambient exposure only causes mesothelioma in 1 in a million, shall we say, if that's it. So your test means that until you do something which is going to raise that to 2 in a million, it should not be treated as material. But if it were the case, God forbid, that ambient exposure produced mesothelioma in 5 out of 20, and you increased the risk so that 9 out of 20 were contracting the disease, it would be absurd to suggest that that increase in risk was immaterial.
With respect, no. I qualify my answer by the acceptance that I've already given that the relative risk of 2 is not absolutely set in stone. And so, taking your Lordship's example, it might well be that a court would say, on the figures 5 and 9, yes, this passes the threshold test. This is material. Because, in your Lordship's words, it would be absurd not to hold that this mesothelioma, this exposure, if viewed on its own, was the cause. Fine, it goes in. Which I think the only point of dispute that I would take with your Lordship's proposition is on the figure of 9 or 10. If what I'm submitting is that, never mind the pure mathematical formula which I've disavowed, if the court were to say it would be absurd when viewing this exposure as to say that it wasn't a cause of the mesothelioma, if you simply look at it on its own, well then it's in. Not difficult. And if the view of the court is that it would be absurd to leave it out, it's a decision which will come quickly. And then one moves on to the application of the Fairchild exercise. But this is the two things that I would wish to emphasize is that in the great majority of cases, this is a stage which is going to go by the board. And it is only in very, very light cases that it is worth anybody trying to take this point. But in those cases, there ought to be a test or meaning for material. And the second point that I should make, again, I think, is that we do not contend that epidemiological evidence on its own will necessarily, by a rigid application of a cut-off point of 2, provide the answer. The trial judge will have many tools at his disposal, will have all the evidence, and will have the flexibility that is inherent in those sorts of exercises.
Sorry, can I just be clear, Mr. Chairman? I mean, these submissions are being made on the basis that this is within the Fairchild exception.
Yes.
I mean, this is deciding what is a material increase in risk, assuming that that Fairchild approach is to apply.
Yes. Yes. I'm now talking about material risk in the context of the Fairchild exception.
Because your first submission is it's not a Fairchild case. We put that behind.
I've made my submissions
Yes,
about
I see, quite.
But you apply the same test to both, i.e. the threshold for the Fairchild test is materiality defined broadly by reference to this doubling of the risk. And if you're right that it's not within the Fairchild exception at all, then causation should be resolved by the same test, whether it's doubling.
But it's a way of looking at the balance of probabilities, either in the context of a single exposure case or in the context of what goes into the Fairchild pot. Mm. And we have provided for your Lordships as an example of the more common approach which may be taken from Cox and Rolls-Royce, which we've cited at paragraph 333 of our case. Cox and Rolls-Royce is itself at tab 6 of volume 1. My Lord, Mr. Cox was a welder. He worked in power stations employed by a number of employers, which gave rise to difficulty, but at paragraphs 8 to 13, the nature of his employment was outlined, and I don't propose to read all of that, but the top of page 116 is typical. This was a statement made by his wife. Line 4, when the boiler came off repairs, we did what we call a strip down. All the time we were doing this, we were exposed to asbestos. We'd be walking about in it, and people working above us would be kicking it down as they walked about. I've even laid down on it to get to some difficult parts of the boiler, and there is a considerable amount more to that extent. Now, in a case such as this, no question of a detailed assessment of relative risks is required, and the approach which would be taken and would continue to be taken by the court is at paragraph 21 on page 119. Which is the passage that we have cited in our case. And it is because that is going to be, or would be, the approach of both trial courts and appellate courts in cases of significant exposure, that we say that imposing some form of threshold is neither draconian nor unduly burdensome, because you will not require to go through the detailed exercise in all but a very small number of cases.
I mean, Cox isn't any support for a proposition that you introduce this concept of reasonable likelihood
No.
or
No.
2 to 1 or anything like that.
No.
I mean, it just shows that in most cases where there's any serious exposure, you've had it anyway.
Exactly. It'll be waved through. There are 3 points raised by the respondents which I would wish to deal with in this area. Can I at least make a start on them? Can I take the court to paragraph 21 of Mr. Melton's skeleton case, which is the Sienkiewicz case. Paragraph 21 on page 10 of the case. It's the suggestion that a sale of the business or would make a difference, or a claimant such as Mrs. Costello would be in a better position if she'd lost her husband's asbestos-contaminated overalls. My response to that is that there are distinct questions to be asked. The first question would be, have there been multiple exposures which, viewed overall, justify engaging the Fairchild exception? And if there were, the question then would be, did the exposure at issue materially increase the risk? And for that purpose, you would look at the exposure for which the defendant is responsible. And if that was not a material exposure, it would be entirely reasonable to exclude that from liability. If you decided that the exposure at issue was potentially material. You might then also consider whether it was dwarfed by all other exposures, so that although he was exposed briefly, but sufficiently to qualify for Fairchild Enclave in employment A, if his exposure in employment B was 1,000-fold, to take an extreme example, there would still be the possibility of arguing within the Fairchild Enclave that it was not material at that stage. But that is not a problem which is affected by the sale of the business, because you would look at the exposures together and see whether Fairchild was engaged. Question 2, should Mrs. Costello be in a better position if she'd washed her husband's asbestos overalls? Our submission would be she's not in a better position unless the same person is responsible for the asbestos on the overalls. And as it happens, Mr. Costello worked for my clients. And so you might well have a situation there where the exposure from the husband's overalls would be aggregated in order to see whether or not there was material exposure overall.
Does your approach on the first point, does this approach depend? I mean, I'm just trying to understand it, but does it assume, or is it the case that the claimant will always be able to show what contribution any particular exposure made to the risk?
There will always be evidence, or there may have to be evidence, about the nature and extent of exposure.
Yeah,
and that may be contested. And at the levels that we're talking about, there may be a contest as to whether they go above the levels of ambient exposure at all.
Suppose you know what the exposure was, more or less. I'm just trying to understand, will someone always be able to say what the effect of that will be on the risk, or will there one up against a sort of Fairchild exception within an exception? In other words, you come to a situation where somebody says, well, I don't actually know, we can't tell what that would have done.
My understanding is that an exercise such as Dr. Jones did is an exercise that can be performed on the evidence in any case.
In any case.
Yes, it's the quality of the output will depend upon the quality of the evidence that can be put into it. That I would accept. And the third question, if she'd been exposed as a childhood as Mrs. Willmore had been, it would not put her in a better position against Greif, my clients, because it would not of itself establish that my clients or the appellant in Sienkiewicz's exposure was itself material. So I would not accept that Mrs. Sienkiewicz would be in a better position if she proved that she had also been exposed as a schoolchild, if the exposure for which my clients were responsible was not material. It would not become material simply because she had also been exposed while at school.
That's the same answer as the answer to the first question, is it then?
Yes.
Yes.
It is.
Well, as I understand you, you're basically proposing a test of materiality, which is such as would enable one, if there was a single exposure, to find on the balance of probabilities that that had indeed caused the thing.
Correct.
So you've got the same sort of exposure, the same threshold,
Correct.
and the Fairchild thing is only dealing with the situation that you can't say which.
Correct. Well, you only get into the Fairchild situation. You only get into the Fairchild enclave if you've satisfied the preliminary test.
Yes.
Yes. And then the question is, have you got the people in the Fairchild enclave such that you've got a Fairchild problem? If at the end of it you've only got one exposer who has in fact given rise to a material exposure, then they're the target.
Can I just have one more go at your materiality test and see if I'm right? That in a way it's fortuitous that it happens also to be the test of causation in what you call a single exposure situation. Is it not the case that you can only put this forward as being a good test for materiality because the risk of contracting mesothelioma from ambient exposure is so tiny that one can say doubling that tiny risk is quite a good benchmark for what is or is not material. But if the risk was very substantial of contracting mesothelioma simply from the ambient atmosphere, to say it's not material to do something which almost doubles that risk would simply not be acceptable.
I accept the first half. With the second half, with the increased level of risk, to say it's not material would not be acceptable is a qualitative judgment because you're imposing quite a big risk, but it may still be legally immaterial. It may still be legally immaterial because it is not such as would have caused the outcome.
On balance, but
On balance.
if you're looking at 200 people, it would have resulted in 25 extra people contracting mesothelioma.
I accept that.
And I thought you were really equating whether it's material or not with whether it's de minimis or not. It'd be very hard to say it's de minimis when it produces that kind of result.
That is entirely fair.
Very well. We'll adjourn.